What is going on, everybody? We are back with the bankruptcy portion of the course. Bankruptcies are pretty easy to get removed. There are a couple steps involved, but you can definitely get bankruptcies removed because they were added illegally. All right. And who we're going to go to is LexisNexis. All right. I mentioned this before in the first portion of the course under protect yourself. So we're going to do LexisNexis. All right. The goal is to put them on notice that the bankruptcy was acquired and shared illegally, and you want them to remove it from their records, right? LexisNexis is who shares bankruptcy information with the big three. The courthouse does not share bankruptcy information with any third-party reporting agencies, right? And we will also be sending, the courthouse mail asking if they share information with third parties to help assist in the removal. Okay, so here is a response from a client from the courthouse that we sent asking if they were the ones who shared information with the big three. And so here is the response directly from the courthouse. And we can use this court response example, not this one per se, but you can use the court response that they give your client or yourself, your family member, whatever. You can use this kind of example that they respond to you with to get this removed from your LexisNexis report, and then also subsequently get it removed from the big three. All right, so it says, I am responding to your letter requesting information about this court's procedures for reporting information about your bankruptcy case to the credit agencies. The United States Bankruptcy Court for the Eastern District of Wisconsin does not report information to any credit agency. All right, court records are public, however, and that means that any individual organization can access bankruptcy court records online to obtain information about your bankruptcy case if that individual organization has access to PACER. All right, I mentioned this before as well. The federal court's electronic record system. Credit agencies can obtain information about your bankruptcy case through the online records on PACER. All right, and then obviously they tell you, Janet Murdoch, all the people, da 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 da. Now, this is good for us because it shows you right away that this is a official court document, and they said that they don't share information. So how did they get a Microsoft report, right? So it's important that when you are disputing with LexisNexis that you're not disputing the validity of the bankruptcy. It's that you're disputing who gave the permission to put it on your report. So people get it confused when they're disputing. They don't use the proper terminology, the proper wording, and that's why they get stuck and they don't get the results they're looking for. If you can't speak the right language, they're not going to understand what you're saying, right? Just like speaking in a different country, you got to speak the language, right? Bankruptcy continue, be patient, be consistent, right? These are some of the federal statutes we use, right? 15 USC 1681A4 refers upon a consumer's right to privacy, as well as 15 USC 1681B-A2. This one's a popular one, it's get used a lot. No permissible purpose, no written instruction, right? It's not the exact quote, it's abbreviated, but you know what I mean. We're going to also complain to the CFPB, Consumer Financial Protection Bureau. All right. Utilize these 3 steps above in round 1. We can always put that into a letter in round 1. You just want to summarize all those things, make it look like you know what you're talking about. LexisNexis typically verifies the account. And that's how we always send off the court request letter as well as the dispute for LexisNexis at the same time, right? Because we're going to get both responses back generally around the same time period, usually within a few days of each other. And then once we have that court document in hand, we can go to the next step with LexisNexis, okay? Once LexisNexis response was verified, we have them trapped in a lie. We already know the bankruptcy courts do not share information with third parties, third sources, right? And we use the response against them. LexisNexis using PACER and illegally sharing information, right, is not allowed. Right? They can't just decide to share the information with whoever they want to. That's called libel, right? Slander and libel. Things to continue to keep all documents, okay? Just keep all documents. 15 USC 1681AE is one of the statutes we're going to use when we're messing with bankruptcies. And then, so since they claim they investigated and verified the bankruptcy, we need to know who they spoke with, right? Congress states in order for them to have conducted an investigation, they have to have spoken to neighbors, friends, or associates, etc. And if they spoke with them, the information provided cannot be factual, okay? We are going to use the paper from the bankruptcy court, the letter from the LexisNexis, and write another letter or affidavit to them, letting them know that they are caught in a lie and that they are in violation. All right. They don't have permission to share information with anybody they want to, no matter what they think their company policy is. Their company policy is directly against federal statutes, 15 U.S.C. 1681B A2, right? No permissible purpose. So we're going to file another complaint with the Attorney General's office. And with the paperwork you have from LexisNexis and the court, we're going to file another CFB complaint as well with all the paperwork attached. Once you've done this, once you've done all that, right? Once that CFB complaint is submitted, right? Once you submitted all those documents, the affidavit, whatever, you're going to call LexisNexis, right? Or you're going to have your client call LexisNexis and ask them if they receive the documentation, right? And then you're going to stay on the phone with them until they remove it. Okay. That's all you're going to do. Call them and stay on the phone until they remove it. And once you're done with that, once that's removed from their records and they send you an updated report, you can now get that stuff removed from the big three because there's no permissible purpose. Usually I tell them right away, say, hey, make sure you tell them to remove it from anywhere else they shared it with because it was shared illegally. Anybody they shared it with without permission is $1,000 penalty per account. So if they shared it with a lot of the secondaries as well, congratulations, that's $1,000 per person. Like, get that stuff off my report. Protect yourself, right? Consumers got to learn how to protect themselves. Okay. So definitely going to get into some more of this. Right. So in case you don't know what a bankruptcy is, right? I know everybody should know, but for the most part, sometimes people don't. So bankruptcy is a legal process through which people or other entities who cannot repay debts to creditors may seek relief from some or all of their debts. In most jurisdictions, bankruptcy is imposed by a court order, often initiated by the debtor. Bankrupt is not the only legal status that an insolvent person may have, and the term bankruptcy is therefore not a synonym for insolvency, right? Basically, if you can't pay what you need to pay back, somebody may enter into bankruptcy. There's Chapter 7, Chapter 11, but it does not mean that it automatically goes on your consumer reports. And I mean, I've been at conferences where people who worked at TransUnion and Equifax or Experian think that anything that goes on in your life is on your report, and that's just not the case, because it's not true. So unless you want something on your report, it should not be there. Okay. This is PACER, in case you've never seen it, right? Public access to core electronic records. This is how they get your bank's information. And they literally just, I mean, they have a list of socials and they just search their social probably once a week, maybe once a month. And they just add information to their database and they just share their database with everybody without consent. All right. Let me just log in here so you can see a little bit more. Paste your login. This is what you do. I mean, that's really it. So if you want to find any case in the country, you want to find bankruptcy by social, I mean, you can find anything you need to on here. All right. Let's see if there's a case against the company we've been doing, using it as example this entire time, right? I don't want to search by court case, sorry. I want to search by name, yeah, by party. Let's see if anybody's sued these people before. Look at that. Over 5,400 results of people who have been suing them, which means I need to narrow my search down. But I mean, look at this. So that means that people are suing themselves, or not suing themselves, excuse me. That people are suing this company, to protect their rights, especially in Alabama, apparently. Good Lord. Oh, Alabama, bankruptcy court. I need to get out of bankruptcy court. Alabama Northern Bankruptcy Court. So this company right here, this is a good case study. We should mess around with this a little bit more. I'm going to actually use them in a future class. We're going to see what we can find out about these people. That way, anybody who ever has Jefferson Capital Systems, y'all gonna know exactly what to do. Pacer does cost money. It's like 10 cents a page or something. So I'm not sure if the searches cost me money, but eventually they'll send me a bill every quarter and I'll just pay that and go from there. All right. But this is where they get your information for bankruptcies. And LexisNexis is where it goes like, it should go like this, right? LexisNexis gets the information. Where they get it from, they get it from Pacer, then they share with the big three. So you stop LexisNexis from sharing it, then you'll have the big three from not having it, and you go from there.